And good morning, everyone. Thank you for joining us for our presumptive conditions. What you should know. My name is Kirk Eller. I am a training coordinator here in the California Transition Assistance Program. And on behalf of everyone here at CalVet, we want to thank you all for joining us for this webinar. First, I'd like to go over a little bit of housekeeping rules. We have our Q&A tab on the bottom of the toolbar and the chat. If you please open the Q&A tab, we will ask if you please put your questions during this webinar in the Q&A so that we could separate out the chat and the questions. My colleague Derek will be putting some resources in the chat for you. There will be our resource book. We will have a PDF of this presentation available in the chat as well so that you can download this for future reference. And we will also be putting in some other links and various things throughout the chat. But please separate your questions out to the Q&A tab, and we will address those at the end during our virtual question and answer. Thank you very much. So today we have Bergman & Moore law firm from Maryland, and they are specialized in veteran claims and appeals for the VA. And we have Mr. James Ridgway for his presentation on presumptive conditions. I'm also going to be going over some quick overview of the California specific benefits. And then also our link coordinator, Lance Junker, is going to talk about his roles and responsibilities as a link coordinator here in the state of California. With that being said, let's get started. My name is Kirk Eller. I am a Marine Corps veteran. I served from 1986 to 1990 as a helicopter crew chief. And also I've been with CalTAP for about 3 years now. I started in December of 2019. So first, let's start with what CalTAP is. CalTAP was actually designed to inform and connect veterans of all eras on the earned federal and state benefits, and then also provide that continued support and assistance as those needs change over time. They like to provide that continuum of care as those needs change by the 5 pathways that we have listed here: our core curriculum, education, employment, entrepreneurship. There's also a 5th pathway for service providers for those that work with veterans. So this is our resource book, the front page, message from our secretary, Dr. Mbasiani. Derek will be posting a virtual PDF of this or a link in our chat so that you can access that. I encourage you to download the PDF at your mobile device and have it available to you all the time. So how can you use CalTAP online? Visit our website at calvet.ca.gov. If you click on the little icon there that's the laptop, it'll take you to the CalTAP portal. This is what it looks like, and you can see all of our 5 pathways listed there. The core curriculum, which is highlighted here, will display your California specific benefits. There's different modules you can browse through at your own leisure and pace on different topics. But if you focus on module 5, it will show you what your California specific benefits are. So what are your California specific benefits? Well, it starts in chapter 1 of our resource book. It has the regional outreach that's listed there, which would include our link coordinators. And then this is a list quickly of our California specific benefits. And again, I'd like to say this is an abbreviated version because we want to allow enough time for our keynote speaker to provide as much time as possible to go through the presumptive conditions. So with that being said, this list of benefits available to California benefits or veterans, if you have any questions about any specific one of these benefits, please address it in the Q&A, or you can contact us directly at CalVet. And we will be more than happy to give further details on each of these benefits. You can see we have the fee waiver for your dependents, the veteran designation on your driver's license, motor vehicle registration fee waivers, and reduced fishing and hunting license, no cost park pass, as well as the property tax exemption and business tax exemption. We also have listed on the right-hand side the different divisions of CalVet: the Home Loans Division, CalVet Women's Division, Minority Division as our CalVet Homes for long-term care, and then we also have 3 cemeteries throughout the state of California. So please reach out to us if you have any questions about each one of these specific benefits, and we'll be more than happy to get to you about that. Other veteran websites, the va.gov. This is where you're going to manage all of your VA benefits through My VA now instead of eBenefits. You can do healthcare, disability, retrieve records, and education benefits. If you have applied for VA healthcare, you can register under My Health eVet, which will allow you to make appointments, send messages to your primary care physician, and your access health records and your prescriptions as well. So like I mentioned, CalVet wants to stay, or CalTAP wants to stay connected with you as those needs change over time. And we like to do that in a variety of ways. One is with your non-DoD email to caltap@calvet.ca.gov. And on our homepage on CalVet, you can register for My CalVet. When you register for My CalVet, you can receive access to ongoing legislation and information about different benefits, as well as our monthly newsletter. You can also add CalVet Veteran Services on social media. The QR code to the top right is all of the social media platforms listed there. And you can also attend webinars like this, and you can fill out our today's survey, which we encourage you to do because we value that feedback to provide continued improvement on these webinars. The survey link is there below, and the QR code that you can access to the right. This is how you register on My CalVet. On the homepage, click on register and provide some information. They will send you back an email. This is what our monthly newsletter looks like. Our Deputy Secretary, Keith Boylan, has a personal message on the front of that newsletter, providing information and monthly topics for our webinars. And you'll also have a link below that to register through Eventbrite on our monthly webinars for the topic of the month. This is my contact information, my email, and also our 800 number. We do answer the phone live. Personnel from the CalTAP answers this phone. So if you have any questions, please call the 800 number. You can email me directly, and we will be sure to get back with you. Thank you. I'm going to turn it over now to our local interagency network coordinator, or LINK, who is Lance Junker, and he's going to give you some information on his roles and responsibilities. Thanks for joining us, Lance.
Thank you, Kirk. Hope everyone is having a good day. I'm just going to quickly go over what the local interagency network coordinator is for CalVet, and how you can reach out to us if you need any guidance or help along the way. So a little bit about me real quick. I was in the 82nd Airborne Division. I was wounded in Iraq in 2007 during the surge. Spent about 10 months in the hospital recovering, and then was medically retired and left service in 2008. And so I kind of have, gone through the transition, have had to navigate the federal VA medical side, benefit side, as well as, kind of navigate the often confusing, veterans world of different veteran service providers and what's available, and, how to really, take advantage of some of the things that we've earned. And sometimes we don't feel that we should. So this right here is the link map. There are 8 regions. These are broken up into the disaster relief, FEMA disaster relief zones, roughly broken down by population. As you can tell, these are not geographically equal. Cole up in the north has a massive territory going south of the capital in Sacramento, all the way north to the Oregon border, and all the way to the Pacific Ocean and over to Nevada. So he's got a massive geographical location, and his job looks a lot different than, say, my job down here in San Diego and Imperial counties, where, we have just a ton of, veteran infrastructure. We have 8 military installations down here. So a lot of my job is helping with that transition out of the military and bridging that gap into the veteran world, where Cole and some other links in these areas don't have a lot of, active duty military presence in their regions. So no matter where you end up in California, wherever you live now, you have a dedicated link who understands that region better than almost anyone in those regions. So if you reach out to them, they can assist you in finding different nonprofits and government agencies and different benefits that you may not even be aware of, that might be able to assist you. So it's great. Great resource to have is to know your link. And they've got all their emails here. You can also reach out to me. My contact information will be at the end of this presentation, but you could reach out to me and I can get you to the right link. Next slide. A little bit about what we do. So we mainly provide outreach to service member veterans and their families within our regions, and we make tons of referrals and work directly with the established service provider network. So whether that is nonprofits or governments or counties, we are there to assist you and get you to the right place. We also assist with local emergencies. So during the fire season, which seems to be year round now, when there's big fires and there are, some of the population is dispersed, they set up these local assistance centers, these LACs, and we'll go out and man a booth, for veterans specifically. There's a lot of things that happen that you might not think about, losing structure. Maybe you've lost your DD-214 and, all the information you need to get new ones. So, we're there to help you, any way we can in those moments. We also provide leadership and advocacy to the local communities, again, whether it's board of supervisors or at the state level, helping, get veterans, answers from the federal VA, all that kind of stuff. Next slide. Again, connecting you to your benefits. So, nonprofits are not on here, but that's a big one because it's not always, easy to know what nonprofits are operating in your region. But, we can help get to the right person at EDD. During the pandemic, we had, thousands of veterans contacting us saying they couldn't get a hold of anyone at the EDD using the main number. And we have some other like side door numbers and different connections we have that we can help, get these veterans, get you guys and gals to the right person and get you the help you might need. Again, at the CVSO office, County Veteran Service Office, we've know everyone that works there and have contacts there, as well as at the federal VA as well. Next slide. I think this is just, my contact information. So I've got 2 emails there. You can call that 1-800 number as well, and they can provide the contact information for the link in your region. Thank you so much, and I'll turn it back over to Kirk so he can continue with this presentation.
Lance, thanks a lot. We appreciate everything you do down there in San Diego County. Thanks for joining us today. And now I'm going to turn it over to our partners at Bergman & Moore. We want to thank Bergman & Moore for joining us today for the presumptive conditions. We have James Ridgway, who's a partner at the Bergman & Moore, as well as the director of training and programs. He also teaches law as an adjunct professor at Washington University Law School, and he's an author of Veterans Law, Cases and Theory, and other publications. And his work has also been cited by the Solicitor General and the Secretary of Veteran Affairs. James, thank you for joining us today. We appreciate all that you do for veterans and the appeals process, and thank you for providing that information today. So welcome, and let me turn this back. And you can take it away from here.
All right, thank you, Kirk. Appreciate it. And thank you to CalVets and Secretary Imbasciani for having us here. I always love doing these presentations. I've been in this business for 25 years, but it was really a service officer back in 1996 who helped me when I was just a law student figure out what was going on with my claim. And I know the biggest impact that we get to make is when we help service officers and everyone else out there get ready to help others. And so this is great work, and I really enjoy doing it. So thanks to everyone for having me here. And let's go ahead and get started talking about presumptive service connection claims. So as always, we begin, we're here to help folks learn how to do this. And, our best piece of advice is always, work with an accredited service officer. So that, if you're on this call and you're not one, this is great information to have. but it's not enough to file a claim on your own. So, but there's always people here to help, and I enjoy being part of that. Today, we're going to talk about sort of 5 different aspects and when it comes to claims based upon presumptive service connection. And we're going to start with the fundamentals. And then we're going to go into 3 specific types of presumptives, Agent Orange presumptives, Gulf War presumptives, and burn pit presumptives. Those aren't the only ones. There's radiation, there's prisoner of war status, but those are the big 3. And so those are the ones we're going to talk about in our limited time. And then finally, we're going to talk about the PACT Act that appears to be poised to pass and how that could change the things that I'm talking about today. So next slide, please. We're going to start with the fundamentals. And the most basic thing to understand, I think, about presumptive service connection is that it is not one thing. There have been many different presumptions created by different laws, by acts of Congress, by regulations from VA over the years. And they have a lot of similarities, but they also have a lot of differences because they were created at different times to solve different problems under different political conditions. And so, the most important thing is to know which presumptive you're working with and focus on making sure you get the details of that one correct. So in order to understand presumptive service connection, you have to start with direct service connection, which I know is going to be old hat for many of you, but maybe not quite everyone. So the basic claim for compensation for a disability in order to have VA provide benefits and care is a claim for direct service connection, which has 3 fundamental elements. You have to have, the veteran has to have a present disability, a medical condition. There has to have been some incident or accident or trauma or disease or event in service. And then there has to be a connection, a nexus between those 2 things, between the present disability that limits a person's ability to make a living and what happened in service. And in most circumstances, veterans have to prove all 3 of these things in order to be awarded direct service connection. Next slide. Presumptive service connection schemes make this easier for the veterans and also easier for VA because it's less for them to process. So if a veteran in general has a qualifying condition and there's different lists for different presumptions and has a qualifying event, a qualifying type of service, then the veteran does not need to provide VA with a nexus. VA is already going to accept that the connection between service and what happened exists based upon existing scientific research. And so, some of the simple ones you're familiar with are, say, presumption of service connection for diabetes if you served anywhere in Vietnam. And we'll talk more about that. Then all you have to show is, I have diabetes, I set foot in Vietnam, or I was on a ship near Vietnam, and that's it. The connection between those 2 things is assumed and the claim is granted. So this makes things much faster and much easier, but it's also important to understand that it's not necessary. You can win a claim for a condition that is not presumptive based upon an exposure. You can win a claim based for a presumptive condition based upon an exposure that's shown through direct evidence, or you can win based without either one of these, and we'll talk about that. Next slide. So the fundamentals that you have to show is you have to show the qualifying condition. And these are phrased in terms of medical diagnoses, something like prostate cancer. And in many situations, these also require the condition to have manifested within a certain amount of time after service or after an event in service. The second thing you need is a qualifying event. So for example, presumption of exposure is usually based upon specific dates and locations, such as service in Vietnam between 1962 and 1965. So if you file a claim for a presumptive condition, one that's on the recognized list, and you also have a presumption of an exposure based upon when and where you served, then VA will usually grant that claim based upon the presumption quite quickly. And when it makes mistakes, it usually is quick to admit and fix those. So next slide, please. Now, so one key aspect is that you can win based upon only the presumption of exposure. One of the things that the courts have explained, and there's court cases like Combi in this material, but you don't need to know them specifically. But one of the things the courts have explained is that presumptions are designed to benefit veterans, to make it easier to prove certain types of claims, but they are not intended to exclude the possibility of proving a claim for a condition that is not on VA's recognized list of things related to a particular type of exposure. And that makes sense in all sorts of different ways. In particular, evidence tends to build slowly over time. We tend to see, certain claims granted based upon direct exposure while the evidence develops before VA ultimately creates a presumption. But just because a veteran has a condition that is not recognized as being caused by exposure to a burn pit or Agent Orange or whatever, doesn't mean you can't file the claim. It doesn't mean you can't win. It just means you're in the world of direct service connection, where you're going to need medical evidence of causation. And the key to that is that the evidence that you need has to be specific to that veteran and the risk factors for that condition. And so it can't be, I'm the veteran's doctor and VA has not created a presumption for this condition, but I think this condition is generally related to exposure to this. It can't be, I disagree with VA about creating a presumption. It has to be, this veteran has this condition and the normal risk factors are something like smoking and family history and working a certain type of plan or whatever it is. And the doctor says, but this veteran doesn't have any of the normal risk factors. And there is some evidence that Agent Orange causes this. And so I think in this particular veteran's case, it's at least as likely as not that it was caused by Agent Orange because the normal risk factors are not present. And so you can get an expert opinion, particularly from the veteran's treating physician, but it's got to explain why this veteran's case is special and meets that standard of being at least as likely as not to be related to the claimed exposure. So next slide. Now we're going to get into the first of the three specific types of presumptives, presumptive service connection based upon exposure to Agent Orange. Next slide. This presumption is very much in the traditional mold of if you have qualifying service and a qualifying condition, then your claim will be granted. The qualifying service is very broad. So if you set foot in the Republic of Vietnam between January of '62 and May of 1975, then you are presumed to have been exposed. And more recently, that presumption has been expanded to those who served on board ships in the territorial waters of Vietnam within 12 nautical miles of the shore. And VA's got a list of ships, but again, it's not perfect, and you can prove that the ship actually was that close. Now, but this presumption of exposure does not apply to folks who merely flew over the airspace of Vietnam. The heavy bombers who were based elsewhere, maybe the aircraft carrier based ships where the aircraft carrier never sailed within 12 miles of the shore. And so they do not qualify for the presumption, except for one particular condition, non-Hodgkin's lymphoma, which was, that presumption was created under a very specific act of Congress in 1984. And the way it's structured, non-Hodgkin's lymphoma is a presumption for those who merely flew over. And I'm not going to cover every presumption exception to rules, but just so this kind of gives you a flavor that there are exceptions, and then there are exceptions to the exceptions because these presumptions were created in so many layers by so many different pieces of law. So next slide, please. Blue Water Navy veterans, this is the most recent big expansion. So in 2019, this was added. And so the territorial seas became an area where presumption of exposure is assumed to have occurred For those who had this kind of service and had been denied before, VA should be automatically re-adjudicating and granting the claims for any presumptive condition. They're not going to re-adjudicate claims for non-presumptive conditions, although you can still prove those, but you'll have to initiate that yourself. But if you know someone who has a prior claim that has not been re-adjudicated, or a Blue Water Navy veteran who's never claimed a condition, they're going to have to initiate a claim by filing a 526. Next slide. So there are many other places where the presumption of exposure to Agent Orange also applies. So there's a presumption for those that served on the perimeter of an air base in Thailand during the war. And this is something that could be changed by the PACT Act. You're going to see some of these notes, and we'll hit that at the end. There's a presumption for those who served on or near the Korean DMZ between 1967 and 1972. We don't know what the word near means. That's not been clearly defined, but the nearer the better, and have a veteran submit a lay statement describing exactly how near they got, because that can be very important. There are some units that have a specific presumption where VA already accepts if you served in this unit, then you're presumed. But even if you weren't in one of those units, if you were near the DMZ and you can prove that, then you can prevail. There's a presumption for those that operated, maintained, or served on the C-123 airplanes that were used to spray the herbicides after they came back. So if you were in Vietnam working on those planes, of course you're presumed, but even if after those planes came back and they were given to reserve units, if you worked on one of those planes extensively, even though you never went to Vietnam, you can be presumed to have been exposed. Next slide. And that's just the big ones. VA maintains a list of 16 pages of other times and places where these qualifying herbicides were tested or stored. It begins in 1945 and goes all the way through 1977. So it's a broad list. But even without being on the list, you can still prove direct exposure through other evidence. And that's something that definitely happens. So once again, you can win a claim using both the presumption of causation and exposure, just one of those two presumptions, or even without benefiting from either one of those presumptions. Excuse me, next slide. So that's the presumption of exposure. And now the presumption of causation. So if you have exposure, whether it's presumptive or proven with direct evidence, there are many conditions that VA will presume are related to that kind of exposure. Leukemia, Parkinson's disease, Hodgkin's disease, type 2 diabetes, prostate cancer, ischemic heart disease, lung cancer. Those are some of the biggest ones. The full list is there in that regulation. Recently, bladder cancer, hypothyroidism, and Parkinsonism have been added to that. And so those are conditions that have been recently added. And if someone has been denied before, VA should be automatically re-adjudicating those. Next slide, please. Now, one important thing to understand about cancer presumptions, not just for Agent Orange, but for any type of cancer, is that cancers can metastasize. They spread from one location to other locations. And that's when things really go from bad to worse. Once cancer starts to spread, that things are really not looking good. But VA's cancer presumptions apply to the type of cell that became cancerous, not to where it was found. So, lung cancer is a presumptive cancer for Agent Orange, but brain cancer is not. And so if lung cancer cells are found in the brain, then that's a presumptively service connected. But vice versa, if brain cancer cells were to be found in the lungs, that's not presumptively service connected. Even though it's in the lung, it's not a lung cell. And so when you're dealing with cancers, you have to focus on the type of cell and not where it was found. Next slide. So one specific type of claim that you should know about is claims for hypertension. So hypertension is something where since 2018, the evidence has said that there is sufficient evidence of an association, that's the specific terminology, between Agent Orange exposure and hypertension. Normally, VA creates a presumption at an even lower level of evidence. So this is a step above what would normally create a presumption, but VA still has not created a presumption. It says that it's carrying out studies, and we don't know why. Currently, these are claims that you're going to have to appeal to the board, and that this could be changed by the PACT Act, but that even if the PACT Act changes it, it looks like it's going to take some time for that to come into effect. Next slide, please. Now we're going to shift to the presumptions based upon service for Gulf War conditions. Next slide. So here, the qualifying service dates and locations are a little bit more complicated. So the locations that are shown in red are the ones where the general presumptions apply. So Iraq, Kuwait, Saudi Arabia, the surrounding areas and waters. And then there's a limited class of presumptions for infectious diseases that applies only to Afghanistan. That's the only part that applies to Afghanistan. So that subset also applies to the area in red, but Afghanistan is limited in which things apply to it, and the time periods are different. Next slide, please. So the Persian Gulf War officially began on August 2nd, 1990, and it continues to the present. We have never, by act of Congress or president, said that this has concluded for purpose of VA benefits, regardless of anything else. And so anybody who's deployed to those areas since August 2nd, 1990, those areas in red, can benefit from these presumptions. Currently, the conditions have to manifest to a degree of at least 10% disabling by December 2026. That's a date that Congress has moved back again and again and again, and it may be eliminated by the PACT Act, but currently that's the law. Now, unlike Agent Orange, there's not a list of specific Gulf War conditions at the moment based upon the exposures. Next slide. Instead, that act of Congress created a framework that recognizes qualifying chronic disabilities. And there's two categories that are created. One is undiagnosed illnesses, and one is medically unexplained chronic multi-symptom illnesses, sometimes called MUCMIs. And that includes chronic fatigue syndrome, fibromyalgia, and functional gastrointestinal disorders, IBS being the big one. But technically, something has to be an undiagnosed illness or a MUCMI to be presumptively related to Gulf War service and not have to provide a nexus. But of course, you can still prove exposure and causation without the benefit. Next slide, please. So VA has a regulation that includes a list of signs and symptoms for these conditions, which include fatigue, skin symptoms, headaches, muscle and joint pain, sleep disturbances, menstrual symptoms, and more. And it's not an exhaustive list. So listen to the veteran, write down all of their known exposures, write down all of the signs and symptoms, make sure that information gets to VA, because it could all be relevant. Next slide. When it comes to undiagnosed illnesses, there's no guidance as to exactly what this means. And here's a graphic from the Government Accountability Office that shows you the types of symptoms that often are present when an undiagnosed illness claim is granted. Again, so the Congress creates these laws in reaction to certain pressures, but the problem with undiagnosed illnesses is that in order to prescribe treatment, a doctor has to diagnose something. And so you don't find people without a diagnosis. What you find is veterans who have lots of different conflicting diagnoses, provisional diagnoses. And so the way you win an undiagnosed illness claim is basically by pointing out that the doctors can't disagree. Like they can't agree what's going on. There's a whole bunch of different diagnoses, but none of them are conclusive. And so functionally, this is undiagnosed because we really don't know what it is. Next slide. So MUCME has a very different definition, and it's in the regulation. So a MUCME, medically unexplained chronic multi-symptom illness, is something that is a diagnosed illness without a conclusive pathophysiology or etiology. So it is going to be a diagnosed illness, unlike a UDX. The key is it's either or not going to have a known etiology or a known pathophysiology. So that means we either don't know what caused it, or we don't really understand what's happening inside the body that's causing the symptoms that we're observing. And the courts have explained that if either of these things is true, then the condition can be a MUCME, with a couple of exceptions. So by definition, diabetes and MS are not MUCMEs, but pretty much anything else can be, as long as one of these two things is not known. And VA doctors get this wrong all the time in examinations. They'll say, oh, like, we know the pathophysiology here, therefore it's not a MUCME. And so they only address one, they don't address both. Next slide, please. So there's also a set of infectious disease presumptions, and these are the ones that also apply to Afghanistan after 2001, not just Gulf War service after 1990. These have a very specific manifestation requirement of to 10% or more within 1 year of separation, or for malaria, it's within 1 year of the incubation period where you served in the malaria zone. And for tuberculosis and leishmaniasis, there's actually no time limit. So once again, you're not going to remember all these rules. The important thing is to remember that you need to go look them up when you have somebody with one of these conditions, and that there could be different time limits and different rules for different types of things. For infectious diseases, it's also critical to remember it's not just the disease itself that can be granted service connection. The long-term effects may be service connected. So oftentimes, once the disease is diagnosed, there's medications to cure it, or at least, remove the virus from the body, but there's still long-term effects. And those residuals are also subject to presumptive service connection. Next slide. Now we're going to shift into burn pits, the most recent area where presumptions have been created. And next slide, please. So I think most of you know about burn pits generally. In the Gulf War theater, plus lots of other deployment areas, service members were instructed to dispose of waste and trash in huge burn pits. So they often, hundreds of meters, if not like a quarter mile long, just huge things where they use bulldozers to push things into these pits. And they burned everything. They burned jet fuel, they burned plastics, they burned all sorts of stuff that produced all sorts of nasty toxins and plumes that could drift for miles from where the burning occurred. And so VA is now acknowledging that these burn pits could cause various conditions. And if you want to know more, VA's got a website with some information, but when it comes to presumptives, let's take a look. So let's go to the next slide. So in order to qualify for a presumption, and the way it's phrased in the regulation is a presumption of exposure to particulate matter. So right now, those two things are fairly synonymous, but we'll see how the usage develops. And so this essentially includes both those that qualified for the Gulf War conditions. But it also includes Afghanistan and Syria and Djibouti and Uzbekistan after 2001. So it's even broader than the Gulf War presumptions. Next slide, please. The dates, again, the Persian Gulf War officially began on August 2nd, 1990, and the period continues to the present day. So if you have someone who's deployed to one of those areas, here, June of 2022, and eventually they come to you as a veteran, like that conflict is still officially in place. And so the presumptions continue to apply to anybody, even there today. Next slide. So now, currently VA has created two types of presumptions. Initially, it created presumptions to certain respiratory conditions, asthma, rhinitis, sinusitis, including rhinosinusitis. That's at a relatively new regulation, 3.320. If you've got an outdated version of the CFR sitting on your shelf, you might not find it there. So, want to keep up your reference materials current. Next slide. Just in April, so just within the last 2 months, VA's added another set of presumptions, these involving various forms of cancer of the larynx, trachea, and lungs. And this is important. This is an interim final rule, which is a kind of a weird thing. So it's a final rule, which means it's in effect. You can apply for service connection today based upon these presumptions, and VA should grant the claim. But it's also an interim rule, which means VA is still working on it, and VA could change that before it goes final. And so you want to keep an eye on this one. Because it could change once it becomes final, hopefully by adding things. But next slide, please. So again, there's differences. So for the respiratory conditions, they have to manifest within 10 years of separation of service. But there's no time limit for the cancer presumptions. And so you just have to know which one you're dealing with. Next slide. Now, there are also different effective dates. And so essentially they're effective once the regulations were created. For the respiratory conditions, it's August of 2021. For the cancer presumptives, it's April of 2022. Now, anything that was pending at the time these were created should be granted. But if the veteran has not already filed a claim or didn't have anything pending, or if they've filed a claim and it was already denied, they need to file a supplemental claim as soon as possible. And of course, if they've never filed a claim, they should need to file a new claim on a 526. So those are different forms, and make sure you use the right one. Next slide, please. Now let's talk about the PACT Act, the Promise to Address Comprehensive Toxins Act. This is a massive bill that 150 pages. There's a lot of things in there, and many of the sections and subsections have their own names. So you may hear about some of these things being created by the, such and such act, or the, this and that act, or the Sergeant whoever act. And that's because the subsection has its own subname, and politicians will use the subname instead of the main name. So just be aware there can be some confusion when people are talking about which act created which things. Next slide. So as of a couple of days ago, the Senate had passed a version of the bill. The Senate's the big hurdle these days. We're still waiting for the House to act, but it looks likely that the version that we saw last week is going to be the final version, but it's not actually final until both houses pass the same version and it's signed by the president. But I'm going to talk about the details as we know them today, but there's a small chance that they could change. So next slide. So the first provision, and again, there's tons of them and I can't talk about them all, but I'm focused on the ones that are most relevant to the things that we're talking about. So it gives VA general authority to create new presumptions based upon toxic exposures and at different places and times. This is actually a huge deal because Congress hasn't really done that before. They gave VA limited authority, such as to recognize new Agent Orange presumptions, conditions, but now VA is going to get broad authority. And so it's not going to have to go through Congress all the time. It's also going to have to be transparent and publish an annual report on what it's studying and what that research looks like. And it's given authority for VA to get good evidence by working with the National Academies of Science, Engineering, and Medicine to commission studies to inform their work. New slide. So one of the provisions amends the duty to assist for direct service connections. We started with direct, we're back to direct. And so direct service connection requires a medical opinion that there's a relationship between the condition and service. And this really lowers the threshold when you're claiming a disability based upon a toxic exposure of some kind. and basically requires VA to provide an exam unless it can bear the burden of showing there's no indication of an association. So these examinations should become quite easy to get, would be our expectation. And they must consider the total potential exposure and the synergistic combined effect of all toxic exposures. So these, the law is going to require much better opinions that we're seeing before. But of course, it'll be up to us and the service officer community to hold VA to this duty. Next slide. It's going to expand the locations where Agent Orange was presumed to have been used. So it's going to add all service and Thai air bases, not just the perimeter, plus for certain times of American Samoa, Cambodia, Guam, Laos, Johnson Atoll. They all have specific subsets of presumptions, but they're all going to be added. It also adds a presumption of causation for hypertension, but it's only fully effective in 2026. And it's retroactive only for claims for DIC, claims based upon the cause of the service member's death. And so you're going to have to take direct service connection to the board for a lot of veterans for many years to come, is what it's going to look like. Next slide. For the Gulf War claims, it's going to eliminate that 2026 manifestation requirement. And it's also going to require VA to provide a Gulf War exam if a Persian Gulf veteran at a medical facility presents with any one symptom associated with the Gulf War illness. So a lot of veterans should be getting automatic full Gulf War workups if they present any one potentially relevant symptom. I don't know why sorry. And then it's adding Afghanistan, Egypt, Israel, Jordan, Syria, and Turkey to that list of places where the presumptions occur. Next slide, please. There's also for burn pits, there's going to be a presumption that uses the expanded definition of Gulf War service that I just talked about in terms of all the locations, and it creates 24 presumptive conditions, including 11 cancers, not just the lung and trachea stuff, but 11 different cancers and other serious respiratory conditions like COPD and emphysema. And again, it's got this weird set of staggered effective dates. So depending upon which condition, it may not go into effect until 2024 or 2025. And so you have to look at the details, and you may have to work on direct service connection before then, and be prepared to jump on the effective date when it starts. Next slide, please. And with that, I'm going to turn it over to Paul Sullivan to just say a couple words about Bergman and Moore and our work with you.
Hello, this is Paul Sullivan. Kirk, are we good to go?
You're all good. Go ahead, Paul.
Thank you. Allow me to wrap up on James Ridgway's comments. Thank you, James. I feel your pain on the coffin and talking a long time. So thank you for going through that quickly and thoroughly. I also want to thank Derek and Lance and Kirk, plus the CalVet leadership, Secretary Imbasciani and Deputy Secretary Boylan, for them reaching out to Bergman and Moore so that we can continue our partnership with CalVet. Want to let you know that for more than 5 years, California's county veteran service officers have worked with Bergman and Moore so that if a veteran ever receives a decision from VA's Board of Veterans Appeals, that's one step up from the regional office, then the county service officer or the veteran can send us their board denial. And what will happen is Bergman and Moore will assign 2 attorneys to look through the board decision. And if our attorneys believe that VA may have made a mistake, then Bergman and Moore will offer, and this is the important part, no cost representation on an appeal from the board to the Court of Appeals for Veterans Claims. Want to let you know that in the past 5 years, Bergman and Moore has been successful to prevail on all 57 of the county VSO court appeals sent to us from California. We're really honored about that. Want to let you know that when it says no cost representation before the court, what that means is our attorneys are paid from a fund at VA called the Equal Access to Justice Act, where the law firm is only paid by VA when the law firm wins, okay? That does not come from the veterans' disability benefit payments, okay? So if you're one of the veterans listening, or one of the county service officers listening in and watching, please know that when a veteran gets a board decision, there's only 120 days for the veteran to appeal from the board to the court. And we want to let you know that we're with California all the way. If you don't know, I used to live in California, grew up there, and used to work at Calvet. And we're really honored to have this relationship with California because California doesn't do appeals to the court, that a veteran has another option to appeal. All that said, thank you again so much, Kirk, and everybody at Calvet, and especially James. Let me turn this over so that we can do the Q&A. I've seen a bunch of questions come up. So with no further time spent, let's launch into answering questions.
All right, I see 4 questions, and I'm just going to start at the top and keep going through them. And if more pop up at the bottom, we'll keep going. So the first question is, I filed a claim for Persian Gulf syndrome in 2012 for fibromyalgia and was denied. I filed again this year and was granted presumptive for fibromyalgia. What should my effective date be? And the answer is that it would be based upon the new claim that was reopened. So many of you may be familiar, or at least have heard of a case called Niemer, or that veterans of Vietnam who have claims related to Agent Orange can get an effective date back to a prior claim if VA adds a presumption. And that is based upon a specific court case that was one for veterans. That's because of the way VA mishandled the Agent Orange presumptions originally, going back to the 1980s. The court ordered VA to, whenever it adds a presumption, to pay veterans back to their original claims for those conditions. But that only applies to the Agent Orange claims. That court case does not apply to other conditions. And so for Gulf War and burn pits and everything else, absent Congress creating a rule that would allow for it, the normal rule is when you reopen, your claim gets paid back to the date of reopening, not to the first claim. The second claim is, our second question is, are there anything about or related to exposure to fumes, ashes, and other debris from a volcanic eruption? And the answer is no. Now, that doesn't mean you can't get compensation for that fact pattern. If that happened, while you were in service, or when your client was in service, they can prove that that happened, and they can provide evidence, a medical opinion, supporting treatises about that caused whatever current condition that they have, but they have to prove that through direct service connection. There aren't any presumptions to make that easier than a normal claim.
Hey there, Paul and James. I just want to apologize. I think we lost our connection there real quick in our building. So I just wanted to jump back in and say thanks for holding it down for a few minutes while we logged back in. So sorry about that, but we're up and running again. So thank you guys.
So am I good? Should I answer any of those questions, or?
Kirk, can you mute your speakers, please?
James,
yep.
Just FYI, before folks gather back, I would kindly suggest that one veteran on the denied for fibromyalgia, that they contact their county supervisor, service officer, and see what VA did in the rating. Because, for example, in the decision that VA requested a C&P Nexus exam, there may be grounds for the service officer to try to find some way to appeal. Obviously, you want to let the veteran know that this is a long shot of a long shot. But VA made a lot of mistakes by asking for Nexus opinions when you're not supposed to have one.
Yeah, and so there. Hello, am I still here?
I'm still
Yeah.
here. Hello.
Okay, good. So yeah, and again, like it's the law, it's complicated. I'm going to be simplifying away important details. So yeah, there it may be exceptions to the rules that I'm talking about, and it's worth exploring. So the last question was about service connection for fumes from a volcanic eruption, and the short answer was you have to prove that by direct service connection. You need to prove exposure to the fumes, and then you need medical evidence connecting the current condition to that. So the next question is, I have sinus issues since returning from deployment in 2004, and it has gotten worse. I am service connected for allergic rhinitis, but I feel that I also have should get service connection for sinusitis. I'm at the point where I have 4 to 6 infections a year, had my tonsils removed. So would this fall under the presumption? And so I think the burn pit presumption, yes, sinusitis is one of the conditions. But you know, there's sort of a couple of ways to approach this. Sometimes the right answer is that the original diagnosis was wrong, and asking VA to change the diagnosis might be easier. But I think presumptive service connection could be easier here. But the trick is, with a claim for an increased rating, there's an opportunity to potentially go back at least a year prior to the claim. And so if it's actually an increase for your current condition, that may open up a better effective date than if it's a claim for a new condition. But that's, you know, you can talk to your doctor about whether it really is a new condition or, you know, a different correct diagnosis for what was previously diagnosed. Next question is, do any presumptive conditions apply to service connection in the Balkans? But open burn pits were used in Bosnia. And so, you know, this goes back to, there are two parts. There's the presumption of exposure and there's the presumption of causation. There is no presumption of exposure that burn pits were used in Bosnia, but that doesn't mean you can't prove by direct evidence, have buddy statements, photos that you might have had to prove that it happened there. And then if you have a condition that is presumptively related, you can ask VA to apply the presumption of causation. Can traumatic brain injury be a MUCME if the doctors can't find a cause? I've not seen someone make that claim, but I would not think so. I'm not a doctor. I mean, I don't, but you know, everything I've seen for traumatic brain injury, that it's a physical trauma, which is, and you've got to identify the physical trauma, which is different from the types of exposure-based claims that we're talking about. So let's see here. Are there any related illnesses to burning oil fields in the Gulf? The answer to that is, the science is really complicated, and we're not trying to figure out what actually was the exposure. And so that's kind of part of the reason why VA framed it as an exposure, a presumption of exposure to particulate matter, because it really doesn't matter if it was oil fields or burn pits. If you were in the Gulf, VA knows you were exposed to all of that. And and so you have a presumption of exposure, even if it was oil fields in your case rather than burn pits. You benefit from the presumptions, and you can get presumptive service connection for the covered conditions. The next question is, my husband worked in the support battalion for the DMZ in Korea. He has all presumptive conditions and has been denied because Camp Edwards is not on the map for automatic approval. Who can we turn to for assistance? You know, we always recommend that you work with an accredited service officer, and if it's necessary, we can you know, help take a case to the court if it's denied by the board. But VA is not bound by the list of recognized units and bases. You know, if he's got buddy statements and his own personal statement about where he physically went during that time period, that is relevant evidence to be submitted. And in a case like that, I would personally argue that the fact that he has all of the different presumptives tends to show that he was actually exposed. Because it's one thing to get one of the presumptive conditions just sort of randomly, because stuff happens to people. but the more consecutive of presumptive conditions that one person gets, the more likely you can argue that there was a common cause that supports his statements that he got close enough to be exposed. The next question is, VA has, continuation of the first one. Yeah, they accept that he has a present conditions. They haven't accepted service connection, and that's the element you want to focus on. Do you recommend to open new claims if one is already 100%? I have all of these questions, but maybe there's more. And my general recommendation is that there is upside, even if you're already 100%. First and foremost, if you have one condition that qualifies for 100% and additional conditions that total 60%, then there's additional benefits available. Furthermore, if it's a heart condition, always make the additional claim for a heart condition, because that is by far the most likely condition. Heart conditions are what most people die of. And if you're service connected for a heart condition during your lifetime, then that makes the service connection for the cause of death for your survivors extremely easy to win. That's practically automatic, but you want to get that heart condition connected while you're still alive. Now maybe there's something where it's, we know the process can be aggravated and you don't have to put yourself through it if there's no upside for it. And so, I can see people making a rational choice that I'm not going to add a claim for hearing loss because I'm already 100% and it's probably not going to have a compensable rating. I wouldn't call you crazy for making that choice, but there are definitely good reasons to apply for benefits, even if you're already 100%. And that's something to talk over with an accredited service officer. The next question is, my medical records show I was exposed to a large amount of sulfuric acid caused by burning oil fields. Can that be used for a claim related to asthma? So, if you've got so that would be helpful. So the asthma, I believe, is already, it was one of the ones that was recently added for the burn pits, if I'm not mistaken. Like I say, don't rely on your memory, always look them up. There's really complicated. And so, if asthma is already on the list, you shouldn't need it. Just being there should be sufficient. If asthma is not on the list, then yes, definitely that would be relevant information to include. And if you need direct service connection, make sure that'll go, you want that considered in the opinion. I have filed for sinusitis and was denied. I have pictures of me burning the drums for the latrines by the oil rigs. Should I refile? And the answer is probably yes. I don't know all the details, but it does sound like, especially if this was filed denied before the most recent presumptions were created, then, if now that you've got the qualifying service and the qualifying condition, that should be all you need. Now, final question that I've got for the moment. I'm 100% already filed for Gulf War symptoms in 2000. What would I be gaining if I was reapplying for the fumes now? If your conditions are already service connected, you don't need to reapply for them. That's not just because there's a different, more accurate basis for recognizing the condition is service connected. That's not going to change anything. The reason that you would apply is either because you have additional conditions that are not yet service connected, or your conditions have gotten worse. And so those would be reasons. And like I said, and I talked already about why, even if you're 100%, getting additional conditions service connected can be beneficial. All right, next question. I was sent a letter from DOD informing me I was in a town where engineers blew up 2 bunkers, exposing us to chemical weapons. And I submitted pictures of the 2 mushroom clouds that went up, but it was still denied. What should I do? I would say these particular VA has granted claims based upon exposure to like sarin gas components, nerve agents, and things. That's beyond what I was talking about today, but that is something that is worth pursuing. I don't know all the details in terms of exactly where your claim is, but that's the type of thing where the board tends to be much more sympathetic, much more on top of it, will get a correct medical opinion if one is needed, will accept your lay testimony if, especially if it's supported by pictures. And so I would at least appeal that onto the board and have them take a look at it. But, again, consult with an accredited service officer, but that does not sound like something you should give up on. All right, I think that's it.
Thank you, Paul. Thank you, James. We appreciate you answering the questions. We're going to move along. That's the last question. This slide, we have the questions and also has everybody's contact information up here for your convenience. We did put the PDF of this presentation in the chat. So if you would like to refer to it at a future reference, you can actually download that and have all of the PDFs of this presentation available to you. I would like to bring up a quick mention of our upcoming webinars. We do have some webinars for benefits and resources to assist aging veterans coming up next week. And then our month of July is going to be focused on fire prevention and emergency preparedness. We have a couple webinars for emergency preparedness, and then also in August, our overview for California benefits, education pathway, and employment pathway on these dates. So please check out these. You can look at the CalTAP portal and look at our upcoming events, or check out our Eventbrite page as well for registering purposes. Again, I want to bring up our survey. We do take this very seriously, the surveys. We take that feedback and try to implement changes and process improvements to make these webinars beneficial to you on what needs that you're looking for. Topics, for instance, if you're looking for a specific topic on benefits, we try to tailor it that way. So please think that this is not going to fall on deaf ears if you just fill this survey out, because we actually use those for the improvement of our webinars. And we would like to thank you all for your service. We appreciate everything that you do for the support and service of our nation. This is our 800 number, and our social media platform is on the QR codes there to the right. I do want to thank our partners again, Bergman and Moore and Associates, and James Ridgway and Paul Sullivan for joining us today, and Lance, our link coordinator. And thank you all for your really good questions. They were answered, and we hope you have a great day and join us again soon. So thank you, and everyone, and take care.